A look at share capital. When we talk about share capital under company, now we're talking about assets of the company, the money of the company. That asset, that money you're using to start the company, sometimes it can be contributed. And when it is contributed by different people, they become the shareholders. That amount of share that you own that gives you right as a member of a company. Now, if you have chosen to register a particular type of company, for instance, you want to register a limited liability company, and the act says that this is the minimum required share capital to register it, you must not go below that required minimum share capital. Okay, for a situation where you have already registered your company, maybe by reason of activities going on in the company, you decide to consolidate your shares or divide your shares. What are you expected to do? Will you just wake up one morning, you start announcing to the public that you're consolidating your shares without looking at what's the act or the steps provided under the act? Now, as a company that now wants to consolidate its shares into larger portions or divide it or subdivide its shares into smaller units, there is something that you're expected to do. The act expects you to call a general meeting, and that it is in that your general meeting that you're going to alter the provisions of your memorandum. Remember that the memorandum is an important ingredient or important document in the incorporation of your company. Now, you must alter the memorandum of your company to entertain the possibility of consolidating your shares into larger portions, because you're already in existence, you already have shares that are in existence. So if you don't want them to now to remain the way they are, you can consolidate with permission of altering the provisions of your memorandum in a general meeting. You can also divide it to smaller what units than you have. But one thing you must do, you will not just carry out this process of consolidation and leave the commission in the dark. You must take steps within 1 month of the concluding the process of consolidation to inform the commission that, look, we have consolidated, we have increased our shares to larger portions. Either if it's a situation where you consolidated part of your shares or all of it, you give all the details of what you have carried out. If it is also where you have divided, you also supply all the details. But where a company defaults in doing this, the commission has every right to prescribe a punishment for such a company by its own regulation. Its share capital can also decide to allot new shares to increase its share capital. But where a company decides that, yes, apart from the fact that we have so and so share capitals, we also want to increase it, it can do so by passing a resolution. And once that resolution is passed by the company has a window of 15 days to communicate to the commission after the passing of the resolution that, look, this is what we have done. We have allotted new shares. And then the commission will take steps to do what? Register those new shares. The law is just very flexible. The law is just very straightforward. You are in business, you want to increase your capital base, you want to increase your shares. The law says what? Call a general meeting, not in any other meeting, not extraordinary, not at